Ladies and gentlemen, I was going to introduce another member of our court. This is Robert Wiedemeyer from Davidson County, who will be sitting on the panel today. Madam Clerk, would you call the next case, please?
State of Tennessee versus Connie Reguli.
Can I reserve 6 minutes, please? 5? 6.
Did you say 6?
6.
Okay. Okay, you may proceed.
Good morning, Your Honors. Connie Reguli of Williamson County, Tennessee. Okay. We are here today.
Ms. Reguli, I apologize. Just for the record, you're here pro se.
I am here pro se,
representing
yes,
yourself.
sir.
Okay. Just clarify that for the record. So.
Oh, sure. Connie Reguli, pro se, Williamson County, Tennessee. We are here today on the application of the criminal statute of custodial interference as it appeared in 2018. This case arose out of a DCS investigation that was initiated in DeKalb County. On Tuesday, August the 7th, DCS investigator Miller showed up at Hancock's home. Although you know little about the underlying facts of the investigation or the life of this family, you do know that Hancock informed Miller that she had an attorney and would not allow Miller into her home. Miller was angry and told Hancock she didn't have to talk to her attorney. You also know that Hancock went to the police station that night to report her son had not returned home. Miller showed up at the police station, and Detective Cornelius excluded Miller from the interview. The following day, myself, as Ms. Hancock's attorney, started making phone calls and leaving messages. Miller, her supervisor Mary Baker, the local offices, and the central office of DCS. No one bothered to call back. My messages informed DCS that Hancock had an attorney and we would cooperate in an investigation. On Friday, August the 10th, I also spoke to the detective and told him I would travel to Smith County to meet with him, but it would take 2 hours to get there. He informed me that he wasn't going to be there in 2 hours, and I asked him if there was anything emergent that I needed to discuss with my client, and he said no. On Monday, August the 13th, I again attempted to contact Miller and Cornelius with no response. I contacted the clerk's office multiple times to ask if DCS had filed anything, and they said no. At about 3:45, I made one last phone call, and they said DCS had just been there and they would fax me the documents. They did not. I would later find out that on Monday, August the 13th, DCS Miller and Hetzel prepared a DeKalb County petition and ex parte order and carried it to Smith County Judge Collins to secretly obtain an order before they even filed it in DeKalb County. They also set a hearing for Tuesday morning and didn't even bother to inform me of the hearing. DCS Miller swore in that petition that Mother had refused to cooperate, but did not inform the court that Mother had an attorney who attempted to contact her. The events of the next few days were the basis of the Williamson County indictment, which came nearly a year after the investigation and after DCS had entirely dismissed their case and released the children to the mother. Ms. Hancock's 12-year-old disabled daughter was never an abused child in need of protection of her mother. It's unfortunate that DCS opted to ignore the attempts at cooperation, but here we are today. I believe today there is little to argue about, given the state's concession that the conviction should be reversed because the trial court's modification of the jury instruction was prejudicial error. However, I'd like to use my time today to address 3 other issues. First, the failure to dismiss the indictment. There's an ambiguous conflict in the legal theories embraced in the notice requirement of indictments versus the requirements that the indictment include all essential elements of the offense charged. The failure to include the essential elements of the crime in the indictment is not about the notice requirement to the defendant. It is about the safeguards of the grand jury process and whether the defendant is charged with a crime at all. The grand jury, like the trial jury, must make findings that the state has met its burden on every element in the case. Although the standard of proof differs, it does not remove this critical requirement. A finding that this indictment should have been dismissed does not require this court to draft an opinion that conflicts with the Supreme Court's 2009 opinion in State v. Hammonds. In Hammonds, the court found that all of the essential elements of the offense were in the indictment. Quoting the Hammonds opinion, "We conclude that the indictment in this case satisfies the constitutional and statutory requirements and sufficiently charges the offense of aggravated assault. The indictment alleges the first element of mens rea, the second element of commission of an assault, and the third element of use or display of a deadly weapon. As previously explained, prior decisions of this court do not require the state to specify in the indictment the precise means or theory by which the state intends to establish each element of the offense. Where all of the elements of the offense are specifically alleged, the indictment sufficiently enables the defendant to know the accusation to which an answer is required and thus satisfies the first requirement of prior established case law." And that is State v. Hammonds, Tennessee Supreme Court 2000.
So we've addressed this issue identically in Wendy Hancock's case. So you're saying that we need to follow Hammonds but overrule Hancock?
I think that there was an error there.
Okay, fair enough.
There was an oversight there. Therefore, this
I
indictment...
don't know that there was an oversight. It looked like the court gave pretty good analysis to it, but you're saying that the analysis is wrong and we need to revisit Hancock.
I believe it, yes, I believe it's
Okay,
incorrect.
that's fair enough. Okay.
Thank you. Therefore, this indictment should have been dismissed for failure to state the essential elements of the offense. Second, I argued in the opinion that when Hancock was final, the conviction of Reguli was a nullity as a matter of law because there was no felony. The state argued that the reversal of the conviction of Hancock was not determinative because it is not a defense to facilitation that the person for whose conduct the defendant is criminally responsible has been acquitted, has not been prosecuted, or convicted. And to convict the defendant of facilitation, the state must only prove the commission of a specified felony and the assistance the accused gave to the person committing the specified felony. However, there was no felony. Even now, the state argues that there was sufficient evidence to show that a felony was committed, but again misstates the essential elements of the offense, leaving out words that specifically define the essential elements. The state puts in its brief after a period of lawful visitation, and the statute and the Hancock opinion define the essential element as after the expiration of a lawful period of visitation. That statute was specific, unambiguous, and clear. If you were to closely review the transcript of May 17, 2021, you will see that even the trial court, before modifying the jury instructions, made a statement on the record regarding the state's burden to produce a visitation order. In Hancock, the court opined, if the trial court had charged the jury with all of the statutory elements of the offense, which should have included the language regarding after the expiration of a lawful period of visitation, the evidence would have never been sufficient to support a conviction for custodial interference. This is because there is no proof in the record before us that the defendant was the non-custodial parent whose lawful visitation period had expired. That's on Hancock, pages 35 and 36. Therefore, one must conclude that no felony was committed. Third, on legal representation. I argue that the trial court erred in failing to give jury instructions on legal representation. The state had argued at trial that the defense did not give proper notice. The indictment itself states that the defendant was not providing legal services authorized by law, which is sufficient notice to the state that this is a relevant defense that might be raised by the defendant. It was undisputed that I was Hancock's attorney at the time, and there was sufficient evidence for the jury to have this instruction and allow them to consider this question. To the extent this court decides to opine beyond the reversal that is conceded by the state, this argument should be addressed. The remainder of my arguments are sufficiently brief, and
your friend on the other side says with respect to the legal services instruction that the evidence didn't give rise to the instruction because at the time that Ms. Hancock and BB were in your house, that at that point you were no longer providing legal services and in fact had not been providing legal services. Help me understand the response, or the best response to that, please.
Sure. Well, there was a lot of evidence about having the opportunity to review the evidence that was in her records, in her phones, in her laptops, and this kind of gets into those underlying allegations that initiated the investigation in the first place, that regarding her sons claiming she was a drug dealer, trying to accuse her of using drugs, and those were all things that needed to be collected out of her devices, and attempting to contact the judge who had entered this order, which at the time my position was it was under the State v. Frazier case. It was not, he didn't have valid jurisdiction based upon the way the state had handled the presentation of that order. All right, finally, the state has conceded that the modification of the jury instructions is prejudicial error, and I hope for an expeditious opinion from this court reversing the conviction. It has been more than 4.5 years since I've labored under this very unusual circumstance where the DA and the trial court judge manipulated the language of the statute to indict and convict an attorney who had vigorously defended vulnerable families against a very aggressive state agency. In this process, the grand jury and 2 citizen juries devoted their time to civic duties to hear a case, and they were misdirected by the system itself. The result for me was that the system stripped me of my career, and my ability to serve the community was abruptly terminated, causing many families to lose their attorneys in the middle of their case. The conviction perverted a judicial election, stole my right to vote, removed me from the membership of the GOP, discredited my name to legislators whom I've worked hard to educate on the reality of the juvenile court system, removed my right to own a gun, and created a plethora of news that label me and my client as felons. And it is more. My reputation as an aggressive attorney is not just Williamson County, but I have worked across the state in half of our 95 counties. The message to other attorneys is kind of frightening. Don't mess with DCS, or they'll do to you what they did to Connie. I appreciate your time, and I will save the remainder for rebuttal.
Thank you. Gentlemen?
Morning, Your Honors. May it please the court, Davey Douglas on behalf of the state. The state does acknowledge that the trial court committed an error in omitting an essential element of the offense from the jury instructions, and that the defendant's convictions should be reversed and remanded on that ground. But it's the state's position that, viewing the evidence in the light most favorable to the state, the evidence is still sufficient to sustain the defendant's conviction. And the state acknowledges here, too, that the sufficiency issue hinges on the meaning of the phrase lawful period of visitation. The statute itself doesn't define visitation, which is why the state went to Black's Law Dictionary in its brief, and Black's Law Dictionary says that that's a period of access to a child. And that's what we had here. We had a court order come down that gave custody of the child to DCS. So therefore, Ms. Hancock was not the custodial parent. The order also provided that visitation would be supervised by DCS. So the order then gives Ms. Hancock essentially a right to visitation with the child. And that visitation, that right of visitation, that period expired once Ms. Hancock knew about the order itself, knew about the order putting the child into DCS custody. And then everything that happened after that was evidence of the intent to violate the court's order, rather than receiving the court's order and attempting to contact DCS or to surrender the child. Ms. Hancock and the defendant met at a hotel, and they then went to the defendant's house, where both the child and Ms. Hancock placed their electronic devices in airplane mode. The defendant gave Ms. Hancock and the child food. She gave them a place to stay, and then police were able to find the child the next day at the house with Ms. Hancock.
What do we do with the sufficiency analysis in Hancock's case?
I think that there's a way to distinguish the two.
Okay, please.
The first way is that this court noted in Hancock that it was addressing the sufficiency in the event of further appellate review, but it didn't actually hold that the evidence was insufficient to sustain Ms. Hancock's conviction. So there wouldn't be anything inconsistent in holding that the evidence is insufficient here because the court didn't reach a contrary holding in Hancock. And
In fact, we could only remand for further proceedings if the evidence were sufficient in Hancock. Is that correct?
yes, Your Honor, that's correct. Okay. And then the second distinction here is that the state's advancing a different argument than was advanced in Hancock. And so that's where we would sort of point this court to the way to find that the evidence is sufficient is to conclude that there was a lawful period of visitation here that had expired, and that it expired as soon as Ms. Hancock actually took possession and had actual knowledge of the order giving custody of the child to DCS. And the fact that the visitation may have occurred in a manner that wasn't entirely spelled out in the order doesn't mean that there was no lawful visitation. It's sufficient here that there was an order giving Ms. Hancock access to the child, therefore visitation, and that period had expired. And one other thing I'd like to point out in the state's brief, I think there was a contention that the state misquoted or didn't accurately quote the statute. The state did quote accurately the statute. It's on page 28 of the state's brief. And unless there are any further questions on the sufficiency issue, I'd like to just briefly touch on the other issues that were raised today. Regarding the sufficiency of the indictment, Judge Greenholtz, you pointed it out. This court addressed it in Hancock, and that analysis applies with equal force here. The court got it right. The indictment was sufficient to place the defendant on notice of the charged offense.
In fact, it was not even a situation where the defendant has to guess as to the crime that's being charged. The language of the indictment would fit only under subsection 2 there under any circumstance. I think at least that was the holding of the Hancock panel.
Yes, Your Honor, that was the holding of Hancock. And then here, it was all one indictment, so count 1 charged Hancock. The defendant was able to look at that charge, then look at her and look at counts 2 and 3 of the indictment. It directed her exactly to the relevant provision that was at issue here.
No one was confused about the nature of the elements. In fact, my recollection from the record is that both the state and the defendant at trial argued for a jury instruction that included the element about the lawful period of visitation expiring.
I believe that they did in Hancock, and I know that the defendant here at least asked for an instruction on that. And I believe the state did as well here too. Okay. But this court, there's no reason to revisit Hancock, nor is there a reason to revisit or attempt to overrule Hammonds. Hancock is perfectly consistent with Hammonds. And then in terms of the argument that there cannot be a conviction because Ms. Hancock's conviction has been vacated, the state would rely on its brief for that argument. And the trial court properly declined to instruct the jury that legal representation could have been a defense to the charge of accessory after the fact. There's just no proof here that the defendant was acting in her capacity as an attorney when she was taking Ms. Hancock and the child to her house, when she was giving them a place to stay and was essentially helping them conceal themselves from law enforcement. And so
what I heard today was kind of a maybe at best characterized as a hybrid. So what I heard today was your friend on the other side saying there were some things during that time after we removed from the hotel room to my house that I was doing in my capacity as a lawyer. So for example, we needed to examine the phone, and we needed to download the phone, and we needed to get in contact with the juvenile court, and so we were preparing to do that. I didn't hear her concede that there were no actions that she took that were outside of her capacity as a lawyer, but how would, if I'm characterizing the argument at least fairly, how does that work if there's kind of a hybrid role at operation here?
The way it would work is the court would simply look at all of the available proof and consider and weigh it and determine whether it would have supported that instruction. So you can
raised by the evidence.
Yes, Your Honor, it's raised by the evidence. And the state would submit here that it's simply the defense was not raised by the evidence, even if you're considering the testimony from the defendant that there were things she was doing, like looking at the phone, because there were so many other things she was doing that were beyond the scope of legal representation. She was meeting with Ms. Hancock and the child, putting all of their belongings in her car so that she could take them away rather than contacting DCS immediately. She was there encouraging, and this was a jury question too. You had BB testify that both the defendant and Ms. Hancock suggested putting the phones in airplane mode. You had the defendant say it was entirely Ms. Hancock's idea. That's a question of fact, and based on BB's testimony, we can infer that there was a request from the defendant to put the planes in airplane mode, presumably to help conceal Ms. Hancock and BB from an investigation that they knew was ongoing. So again, just considering all of the weight of the evidence, it wouldn't have supported the instruction. And so the trial court properly declined to give it. And unless there are any further questions, we would ask this court to conclude that the evidence is sufficient to sustain the defendant's convictions while reversing and remanding for a new trial. Thank you, Your Honors.
Thank you. So I opened the Hancock opinion because I want to refer specifically to that. So in the Hancock opinion on pages, it's starting on, basically on pages 7 and 8, where they're talking about the indictment. And the Hancock opinion deals with the single argument of notice to the defendant. What I am saying here today is that State v. Hammonds is more than just about notice to the defendant. And constitutionally, the defendant has the right to know that the grand jury was charged with all of the elements of the offense. Otherwise, you cannot know what the grand jury considered to reach their conclusion of probable cause. And so it says here, on appeal, rather than merely addressing the sufficiency of the indictment and whether it gave proper notice to, well, it talks about the state's argument. But up here, it says, while the indictment left out the language referring to the expiration of the non-custodial parent's period of visitation, something we conclude later in this opinion is an essential element of the offense. The defendant was surely provided with sufficient notice to surmise the selection of the statute she was accused of violating. So Hancock addresses whether it was sufficient for notice. I'm saying it did not take the next step and say that in Hancock that Hammond, State v. Hammonds, would require that the essential elements were set forth in the indictment. So I hope that is a little bit better explanation for you on that. Other than just kind of cleaning up my argument there, I really have nothing else. Is there any other questions? No other questions.
Thank you for your time.
All right, thank you.
Madam Clerk, are there any other matters on the morning docket?
No, sir.
Then we'll stand in recess until 1:30 this afternoon.